I think for our regular daily life, not even talking about business, just for your regular daily life, you may consider to have a safety box with any bank, okay? So I think it's not a surprise, right? For some of you, you do have a safety box under your name, or you have a joint account with somebody else, okay? So by the way, let me pause for a few seconds. Anybody doesn't know about safety box?
I don't know.
Safety box.
No,
Safety box is the bank. You have the bank, say you have a checking account. You have a checking account with Bank of America, for example. Then you can ask the teller or the manager, ask about it, say, is any chance I can rent a safety box?
Oh,
I can rent a safety box, and you can storage your jewel, diamond ring, any valuable item. Okay, say stock, secured certificate.
yeah, okay, I know that.
This is called safety box. Okay. The reason why I want to bring this issue up, okay, because you need to be very careful. Okay, be very careful. Okay, because we are talking about chapter 21. Okay, this is bailment. This is bailment because number one issue, by law, the bank should provide very secure, very safe to protect your assets in the safety box. So you can see the wall is very thick, right? Even the bump probably cannot break it. They're supposed to, and they need to provide very detailed procedure. Say for example, if your name is not on the registration, you cannot go there. Even husband and wife, they don't care. As long as your name is not under the name list, you can go there. And then if your name is there, every time you go there, use your key and also the manager key, only under the two keys, then you can open up the box. Otherwise, no anyone can individually can go there. Okay? That will be fine. That's not the issue I'm talking about. The issue is you must be very careful because there is the risk. There is the risk you may lose the thing you put in there. Be careful, okay? Number one issue, if you owe any money or liability to the bank, then the bank can may forfeit your safety box. Forfeit is so easy. They just disable your assets, right? They just disable your assets, then you cannot get in there. The other risk is from the third party. Be careful, okay? Because in the past few years, we know the economy is so bad in the United States. So I have handled so many debt defense cases. If one person owe money to anybody, say for example credit card company, and not surprisingly, credit card lender or bank and finally obtain the judgment against this person. Right? Well, in the United States, even the bank received the judgment. Judgment by itself mean nothing. Okay? The judgment only declare, okay, this person owe so much money to which bank. The balance is there. And from the day of judgment, the judgment good for 10 years. Judgment good for 10 years, okay? And the annual rate is 10%, which is better off. 10% is much less than 29% or 30%, which is the regular rate charged by credit card bank. So judgment by itself does nothing good to the bank. However, bank may use this judgment to attach safety box. And there was one case happened to my client. I cannot never imagine this kind of thing happen. I cannot never imagine. Okay. The thing is like this: mom owe money. Okay. mom owe money to a certain bank, and the balance is not even too big. $6,000 judgment, okay? And for some reason, I don't know why, mom joint account with daughter. I don't know why, okay? And the safety box is open under the name of daughter. And daughter does not owe any money to nobody. So daughter is totally clear. And daughter just keep jewel, diamond ring, such thing in the safety box. Very valuable. Okay, $100,000 valuable there. And mom only owed $6,000. And for no reason, I don't know why, this bank found out mom's name is on this joint account. Then the safety box attached. You can imagine how mad this daughter gonna be, okay?
But would it have been better if the safety box was open with another bank?
Doesn't matter.
Doesn't matter?
Okay. Her question, she just brought up one issue. If judgment is under bank A and the safety box open up with bank B, still cannot protect it. Because once the judgment issued by any court, this judgment becomes valid throughout states, 50 states. And you can imagine thousands of bank branches, they will be under the risk. I shouldn't risk, because if you owe money, you should pay off. But I just cannot figure out why this mom still want to keep the joint account with anybody else. So this is the risk. I just want to remind you. Okay, for business reason, you should consider it. If one debtor, the bottom line generally is debtor do not joint account with anybody else. That is the bottom line. Okay, yes. Let me answer the questions.
Yeah, I'm just wondering, would those